Hello and welcome back to the second part of the first episode of the SAIPAR Podcast. In the SAIPAR Podcast, we're shaping ideas and informing change. In the first part of this episode, we promised to discuss Bill number 7, which currently stands as Act number 13 of 2025. Even though it has been passed as an act of parliament, we think most of the conversations that we had in there relating to the general constitutional making process and recommendations for constitutional making in Zambia remain relevant, and therefore we want to share the contents with you. We thought it would be good to share what Professor Ndulo had to say about constitutional making generally, and how the principles of constitutional making apply in Zambia, and how we can best create a constitution that serves the Zambian population. Join us in this episode as we delve deep into that. I've exhausted all of my questions about SAIPAR, and I'm ready to ask about your thoughts on, first of all, the constitution amendment process. Yes, just the beginning of what we're now calling Bill 7. What are your thoughts on it?
On the constitutional making process in Zambia?
Yes.
Yeah, so I actually think the debate in Zambia in terms of constitution making has never been properly guided, and I'll give you a little history here. First of all, at the independence, what we had is what in constitution making period is called Lancaster model of the constitution. And that constitution was not unique to Zambia. It was called Lancaster because it was developed in Lancaster House, the colonial office in London. And the constitutions that were developed were similar. So if you look at Ghana, look at Nigeria, look at Kenya, those were all the same. Botswana, they were all Lancaster models. So one of the problems, of course, in terms of the Lancaster model was that there was very strong UK influence, because it was a colonial model. In terms of participation, the delegates were chosen by the UK, and often it was chiefs and political parties. So, and it's also remarkable that, of course, not remarkable, but sad that if you look at those processes, they were not reflective of even like gender. In most of those processes at independence, some of them had hardly any women at all. I think I'm not sure about the Zambian, maybe one, but generally that was the position. Now, at independence, it was understood that this constitution was very much British. One of the shortcomings we must remember is that Britain does not have a written constitution. Up to today, they don't have. There's nothing like a constitution in Britain. It's just, customs and that kind of thing. And of course, the British now take pride in saying that our constitutions are for like these new states, young states. I see. Look, we're a democracy and we don't need those documents, So there's nothing in Britain that says that if you win elections, you'll be prime minister. No, it's no document. So when you look at and that has its disadvantage in the sense that the model of the executive in the independence constitutions, to me, was the governor. You see, because the British ran the countries with governors. So that developed into a very strong executive, very strong president, because that's the model they had, And you see it whether it's in Tanzania, whether it's in Ghana, Nigeria. It was even in Jamaica, you had what you call Lancaster model. They all had the same. Mm-hmm. So the nationalists at the time, the idea was that after independence, at some stage we would develop, a more modern kind of constitution, that would happen. Uh, Unfortunately, that never happened, and it's not even just Zambia. Whether I talk about Nairobi, Kenya, or whatever, instead they concentrated. They made the amendments that were made were actually concentrating even more power in the executive. So if you look at the Kaunda era, there were a lot of amendments, but they were all really towards putting more power in the president. There was no real effort to democratize in the way that the promise was there. The Bill of Rights section in these constitutions, the British never had the constitution, as I told you, so they didn't have a Bill of Rights in Britain. So they took the European Convention on Human Rights, and if you look at the language and the rights that are there, they are the same, and they were the same in Nigeria, in Ghana, and that sort of thing. But to sort of develop our own predicament. So what happened then? The first major amendment in Zambia, there used to be a referendum clause that you couldn't change the constitution without a referendum. And then I think around 1968, the UNIP government had that campaign to amend the constitution, and it was titled "Referendum to End All Referendum." And it was couched in, attack of colonial, that the referendum was colonial, and all these sort of things, And the Zambian people passed that referendum, so it ended
All referendums, yeah.
all referendum, and that made it even easier for the government to now even continue to change constitutions. So we then come to 1973. You have this commission, and they come out with now actually a one-party state, so all those things might not have been possible if we had had all those referendum clauses. But now we didn't even need a referendum, right? Because they had been abolished, mind you. So we had the 73, and then of course we saw more concentration, even in city councils. When you look at city councils now, it's forgotten that part of the problem was that there was an attack on the system that was in place. We had mayors all over, and they were elected by ratepayers. I mean, okay, you could argue that it was discriminatory because it tended to focus on ratepayers, but that system of mayors was abolished, and in came governors, throughout the country. And again, governors were centrally appointed, all appointed by State House. So they were no longer elected. So the next, of course, and that's not unique to Zambia, that I'm trying to point out. It's you can go to Kenya, you see the same story. 63 Kenyan Constitution. Then by the time of Moi, it was one-party state. So everywhere, Ghana, Tanzania, all one-party states. Now, of course, this led to a crisis in governance in terms of there's also a decline in economic performance in these countries. So a lot of unhappiness developed. So what we see is that the catalyst really was more or less like the collapse of Eastern Europe, in the late 80s, 89 or something like that. Then we begin to see that there's a movement for democratization, that to a more democratic constitutions and to all that. And of course, the collapse of Eastern Europe helped because socialism was no longer, really dominant in terms of the model. It was no longer like you can say Eastern Europe and that sort of thing. And I remember having a funny conversation with a friend in Johannesburg because it was the time when we're doing this South African process, and you were saying that it was difficult for socialists to operate during that period because it's like uh, your father disappears, So the mentor, Eastern Europe, was no longer there, to push this one party state stuff and all that sort of thing. So it's like you're stuck with the product, but the father is gone, you're no longer there, and but that's just an aside comment. But what then happened is that you had now strong movements towards democratization, in the one party system. And so the atmosphere was conducive because Eastern Europe had collapsed. But even banks like World Bank never used to interfere in governance. They would say that they are not in politics, and that kind of thing. So they actually facilitated the emergence of these kind of one-party state systems, which are very undemocratic and all that, but all that started to change, in the 80s. So today, for example, if you read World Bank documents, they are very strong on governance and things like that. That's not the case, before the changes. So what we then have is, of course, in the context of Zambia, 91, Kaunda decides that, we should do, he will allow this, multi-party system. So MMD is formed and elections. And to his credit, Kaunda opted to be elections when he still had like 3 years to go in his term. And that's because I think he had every confidence that he would win, because it was quite a shock for him when he lost, Yeah. So, of course, we had the 91 elections, and they resulted in Kaunda losing and then the MMD coming into power. And MMD had promised to have a proper constitutional process to review so that we come up with a durable and a good constitution for the country. Yeah, so that was the objective. And now here I would like to add that it's not unique to Zambia again. Kenya had the same objective. They were saying this, and they were going to do that. In fact, Kenya ends up with 2 or 3 processes. You had the Bomas process. They even had the referendum, which defeated the constitution. Same with Zimbabwe. They had the referendum 2000. The constitution was defeated, and we can go into the reasons why this was happening. So now let's focus on Zambia. So Zambia had this promise to develop a new constitution, but we've never succeeded to. Yeah, and so there was an attempt with the Manakato report. You had so many reports. There's the Vunga report. There's all these processes. And for me, actually, one of the best drafts, I mean, one which we could have worked on better, was the Manakato report. Was really quite good in terms of the drafts, in my view. I mean, but that's just me. That's what I think. So the challenge in Zambia has actually been how to develop, a comprehensive and a constitution that is, uh, uh, you know, uh, acceptable to everybody and that sort of thing. Now, again, here I would like to add that it is not unique. The same problem Tanzania, even today, the Tanzanian process has collapsed. In terms of, because in the end, I think 3-4 years ago, the opposition just walked out of the whole process and that sort of thing. Ghana is still trying to. Because the constitution they have in Ghana now is very much a Rawlings constitution. The one was president in a military coup situation. And so we've had this objective and we've failed. So in order for me to think about why and what's happening, and also I can relate to now, is that I would like to look at the 3 highly successful processes in terms of producing a constitution. So you have Namibia process, you have South African process, both the 93 and 96 constitution, and of course now Kenya, and we can look at that. The others are still struggling, including Nigeria. They're still struggling. They're still struggling with these colonial drafts, and always promising this. And I think one of what I saw in South Africa, I especially come to unpack because I was there the entire period, and I think probably attended 90% of the meetings. Is that first, of course, we all talk about people-driven constitution. We must develop a people-driven constitution, mind you, the question of the first constitution in the world actually to refer to people as the source of sovereignty and source of power is actually the American Constitution. In 1789, they are the ones who use that term first. Yeah. But one of the challenges, of course, is that when you talk about people, it's not defined. You have to develop a way in which these people are going to express their their views on the constitution. So when I talk to you, Maria, I would say, okay, we agree, people driven. But who are these people? How are you going to mobilize
Yes.
them? You want forum? What kind of thing? And that's one of the challenges in Zambia. People talk about this is not people driven. This is people have not been consulted. I'm like, yeah, but what's actually that's a preliminary issue you must agree with. To say this is the way the people are going to express their views. So if you look at the South Africa, for example, or Namibia first, the people in Namibia were represented in the context of the Constituent Assembly. So that became the way, the vehicle through which the people's views were done. And now in South Africa, remember that initially they had CODESA, Conference on Democratic South Africa. They tried to develop a new constitution. I think it collapsed in 92, 92, 93. It collapsed. There was no agreement. And then they spent, most of 92 thinking about what will happen, and part of 93. And the framework for the 93 constitution in South Africa was the multi-party conference. So that was the organ through which the people's views were going to be collected and expressed. So you had that. And the multi-party conference, was very interesting in the sense that what was decided was that you have, all political parties, all, whether it's a paper party or what, we don't get into those arguments. Every political party in South Africa in 93 was invited to the multi-party conference. And it ended up with 28 political parties. And the ANC initially was like, we're the biggest, so we should have it. And Mandela said, no, we have no proof. So every party, whether you are a small party, same number of delegates in that body. So that body is the one where the way people are expressing. Now, in our context, we've never resolved that because a lot of NGOs, I would say, why? Because some of the NGOs are specific topics. They're gender, they're this, they're that. So why should they think that they represent everybody? They don't. You have to work that out. That who actually, what's this forum? What's the forum that you're going to use? Yeah, and that's critical. So then you look at the other aspect that once the forum had been decided in South Africa, they decided on the role of experts. So if you look at the multi-party conference, you had experts, and here by experts, I mean real experts, not somebody within the constitutional court the next day I'm an expert. That's not what we're talking about. We're talking about people who are acknowledged to know about how these things work in terms of constitutions. They have a history, they have expertise, you can rely on them. And the experts, their role was to feed into the multi-party conference. So they would show what's possible and why a certain provision cannot work and that kind of thing. And you do that, So if you look at the composition of experts, actually it's very fascinating. The same kind of experts in Namibia, people like Chakoson, the late Chakoson, the late Mohammed, people like Abisaks and all that, they were the same people in Namibia. And interestingly, they are the same players in terms of acknowledged expertise. They are playing a role in South Africa itself. And some of them in Kenya too. You see, Kenya, when it came to experts, decided they were looking for real experts. So they had a mixture of domestic experts and international experts, in Kenya. And they formed what they called the expert group committee of experts, which was 9 people. And almost half of that was actually external. People identified for their knowledge about these things, Uh, and I think that's why we go to quality too when we talk about SAIPAR. The fact that in our context, so many people, sometimes it's even becomes difficult to claim to be an expert because you get grouped with these people that call themselves experts everywhere. So it's better that you're not an expert at all, in the context of the way the term is used in Zambia. And we won't get anywhere. We have to recognize the role that this thing requires expertise. It requires consultation with people, but the people will have to have a forum. So in South Africa, as I pointed out, it was multi-party conference. In Namibia, it was a constituent assembly. In Kenya, you had the same process that they actually did that. And in all these processes, the key thing was the role of real sound legal advice. Because I remember again. I'm sorry that I quote Mandela quite a lot, because I remember an incident and I think Bezos in his autobiography mentions this, that at Kempton Park was sitting there and Mandela said he was coming to address the ANC group before the talks. He came there and he said, I just want to, everybody was expecting a big speech and all that. But he said, I just want to tell you that this is not an ANC project, this is a national project. And he left. He didn't say anything else. So it's like everything is sunk, and people are like, wow, you have to reflect on this. But he had that impact that you look at the big picture, that here, because you can disagree on policies later and all that. That's what governance is about. But the structure, in terms of how the government, the state is going to be organized, that should be something that is agreed on and is permanent, Yeah. And you have to make deliberate steps to ensure that this happens. And when you agreed on a forum, it is cordial discussions. This name calling, insulting, I never saw that, in all the process that I've been involved in Kenya, in South Africa, with the coffee, tea, breaks, and different people. And even to ensure that the process in South Africa, for example, in order to ensure that everybody felt that they are part of the process, the meetings, every week, the chair changed. So each one of those 28 parties, small or big, they actually had a chance to chair the conference. Because this week it was the IFP, next week the ANC, and it was part of building a culture that we can talk to each other and we can come out with something. Yeah. So that's the thing that I noticed. And even with respect to the final constitution in South Africa, 96, it was the same. You had thematic. First of all, they agreed on general principles before negotiating the constitution. 26 principles, like independence of the judiciary, this and this. And then after the conclusion of the elaboration, you test yourself to say, did we meet these goals? Is it really independent judiciary we're creating? Is it this? So that was very, very important to do. Yeah. So, and that's one of the things that I see in the weakness in our processes in Zambia. That if you look at the 2016 constitution, which I'm surprised that some lawyers in Zambia say it's a wonderful document. I can't understand that, because there are so many mistakes in the document itself. The way it deals with things and that kind of thing. It shows really lack of professionalism, in developing this. And I'll tell you, for example, that in both South Africa and Kenya, you'll be surprised to find that after all the negotiations and agreed on the text, to clean up the document, the draftsman who finalized the South African Constitution is the same draftsman who finalized the Kenyan Constitution. He's not political. You just called him, say, no, finish this, look through this, and the guy is actually called plain English draftsman. He's expert. He would show you the problems with language and all that. And he's a Canadian guy. Canadian, I can't mention his name now because it's not fair to him. But he was the same guy. And when I worked in Somalia, he was the same guy there. So you can see that people do recognize expertise and benefit from it because it's for your benefit. It's yours. It doesn't belong to the guy who's advising you. You take advantage, what is right, and it's yours, and you stop there. So, yeah. So now coming specifically to the Zambian situation, again, I think that the role of experts, I could go on and on in terms of the processes that have been involved, and I can show you that the benefit of expertise, the recognition of that. In Zambia, the model that was used, which is Kenya, which is Tanzania, is this Inquiries Act. They would appoint a commission, Malakato Commissioner, the Inquiries Act. The Inquiries Act was never put in place in order to deal with constitution making. It's actually an old colonial statute which applied to all colonies. And the British used to use it to inquire in specific. In Zambia, there was, if you go back, you see mine workers, riots, Commission of Inquiries Act. That's what it was used for. And it was never for developing a constitution or agreeing on a constitution because it was a report to the president. That's the model of the Inquiries Act. And the president has, the ability to reject or, accept whatever the recommendations are. And an example of the disastrous effect of the Inquiries Act was Zimbabwe, actually, in 2000. I happened to have been in Zimbabwe that time as a consultant for IDEA during the constitutional process. And it was developed by this inquiry, huge commission, 400 people, chiefs, priests, and all kind of things, they're all claiming to know something about constitutions. Yeah, maybe. But really, you don't benefit from the process. So what happened then in the 2000 constitution in Zimbabwe is that they changed it. Mugabe changed a lot of the provisions which were in the draft that was presented to him. And then they had the referendum. And of course, the referendum rejected the constitution. And you see, the problem with the referendum also is that you have to do something well so that when you come to a referendum, it's legitimization that you're looking at, celebration, legitimization. Because a referendum cannot draft clauses. It cannot. It has no capacity to do that. So you end up with a dead end. So in Zimbabwe, 2000 rejected the dead end. In Kenya, the Bomas draft is rejected referendum is the dead end because you have to start everything, all over. And that's why, and remember that in South Africa, if you do something well, like they did with 96 Constitution, there was a provision to have a referendum in South Africa. But first of all, they are very unique process in South Africa in the sense that it was agreed that after they finished the draft, they should give it to the Constitutional Court to go through the draft and advise them as to whether they had met the principles that they said they would meet. And the first submission, the Constitutional Court rejected a lot of provisions. And they didn't argue, they went back and perfected that. And the result of a clear, system was that when the constitution was adopted in South Africa, there was then a question of, do we have a referendum? And there was not a single political party that said that they are opposed to it. So what's the point? So they never had a referendum because everybody agreed that it was a great document, it's this and that, and that's it. So I just bring that out to emphasize the need for proper process, which we lack in our context. Now, coming to the current debate in terms of Bill 7, I don't want to go too much in detail examining the actual provision in Bill 7 because then It's not the policy, the framework. Of course, I don't agree with everything that is in Bill 7. But the debate right now, to me, somebody who works in this field, I'm actually quite surprised in the sense that, including the Constitutional Court, they seem to confuse amendments with developing a new constitution, where you need this legitimation in terms of uh, the process. So the difference is that when you are developing a constitution, we are talking about these processes like the one I'm talking about, Kenya, South Africa, the Constituent Assembly. That's what you do. It's a people-driven thing. But once the people have agreed on a draft, remember that basically that entity doesn't continue. It's dissolved. So if you look at the Constituent Assembly in South Africa, it disappears once the constitution is developed. The same in Namibia, the same in Kenya, everywhere. It's not a permanent thing because it's a process. So they've delivered. But also, we have to remember that there's no way in constitutional development you can ever avoid parliament. Why do I say that? Well, that constituent assembly or whatever has no legislative powers. It cannot legislate a constitution. So that's why it's important to have a framework which works well, and you realize that whatever you agree on, you would have to take it to parliament, to become a law. Because the constituent assembly cannot make a law. Where is that power that you can actually declare a constitution is a law? It repeals the old constitution. No, it cannot do that. It can't. And there's no constitution in the world which provides for how a constitution is going to be replaced. And that's why you need the agreement in terms of the process. Even if you go to American Constitution, does it say how you can replace the American Constitution? No, it doesn't. And you have to agree on a process that this is what we're going to do. And then you can't avoid parliament. And the same thing in South Africa. After Kempton Park, you still have to take it to South African parliament. Forget about whether it was representative or not. It had to pass the law to make it the legislation. So that's one thing. So the other thing is that the difference between making a new constitution and an amendment is that amendments are regulated by the constitution. You have to go to the constitution to see what you can do. That's not to say that there should be no consultation. I mean, of course, if you want your whatever amendment you want to make, you must be informed. This is what we're talking about: research to make sure that it's correct. It includes public participation, but of course, public participation, as we say, that people participation is not defined. It's not like a template that this is how the public is going to participate. Show me where it's written that this is how actually. You have to frame that. You have to design that and be happy, and everybody be happy. And one of the other things I should mention that in all these processes, like the South African process, whatever, there was never any voting in the actual negotiation of constitution. Never. Not one provision in Kenyan constitution amendments, whatever, was adopted by a vote. No, it was consensus. Because when when a party is defeated on a provision, they will fight you at some stage to take revenge at what you did, in other things. So the entire South African constitution was adopted by just consensus. We just talk, and they would say, well, if you can't agree, we talk more. Let's see, can't you see this? This sort of thing. That's how, you build the understanding, the cooperation, so that in the end you get the best. Yeah. So the amendment, you follow the constitution. But again, I emphasize, that doesn't mean that you shouldn't consult people. I mean, any successful policy change, amendment must have backing, isn't it, in terms of people. But what I'm saying is that it's not as if there is actually a template, that this is, you can look at what other countries have done, Constitutional Assembly, this and this, but Constitutional Assembly is used really for the whole the Constitution. Yeah, and that's why I say that when I look at the debate on 7, I get surprised. I also get surprised with the Constitutional Court actually saying that they can declare a proposed bill unconstitutional. I've never heard of that, because it's a proposal. How is it against the Constitution? Because we don't even know how it will end up. Maybe it will be rejected in Parliament. It's an act of Parliament that you review. The only country in the world that I know that a court has, that power to review a proposed bill is Sri Lanka. And in Sri Lanka, it's tabulated in terms of how that process is going to work if you're going to take that route. But the common approach in all jurisdictions is you wait, because it's a proposal, and it's just like you can't punish an intention. You can't, if I say I want to steal from ShopRite, that's just an intention. You can't come and arrest me because I'm saying I want to steal in ShopRite, because I might not, even if I arrive in ShopRite, you have to wait until I actually do the act. There's an act which we can say, this act now we are going to decide it is unconstitutional. So I think that the courts themselves must be very careful and be very clear, in terms of their role. And remember that judicial review was actually an invention of the courts. 1803, the United States, Marbury versus Madison. Every lawyer knows that, that is the first time this power was propounded, to say this is the thing. So the judiciary created. Now, of course, in most countries, then they proceeded to legislate that, but it's premised on unconstitutionality, which means against the Constitution, because you've actually taken an act which you can describe, as having taken place. So if it hasn't, I wonder how you can actually say the thing is unconstitutional, So that's my view. Yeah. So now, when you come to amendments, if you look at our Constitution, they are, what sometimes is called basic structure of the Constitution, which means that you actually have two ways. There are amendments which you cannot do in the Zambian Constitution except with a referendum. So usually that's a doctrine that is called basic structure, and it identifies certain very fundamental parts of the Constitution, which you cannot do. Usually in the Zambian context, like Bill of Rights, you can't change. You can't pass a law to say Zambia is no longer Zambia. All those things, they are very basic. So it's legislated in South Africa. If you go to South African Constitution, it actually spells out areas which are called basic, which then require much, much more onerous ways of making an amendment to those provisions. You often a referendum and 2/3 majority in parliament. The same in Kenya, you have that. Now, India never had it in its 1949 constitution, but they developed it judicially. That they called basic doctrine. So they've identified certain areas of the constitution which you cannot change just like that, because they say that it's fundamental to the structure. You can't, for example, abolish the independence of the judiciary. You can do this. There are many. It's up to the state to list those, to the constitution, sorry, to list those things, in terms of what is not amendable easily, and all that. So clarity in what we're really focusing on, it should be critical. And when we talk about the process, let us define exactly what the process is. We agree on the process before we go to substance. You go to substance, you're still arguing about the process. So how are you going to agree? In all these countries, if you look at South Africa, Namibia, it's process. And the role of experts is actually, to me, critical. Even, Zimbabwe, the 2012 constitution in Zimbabwe, I mean, I have to say I was involved too. And the Americans had a workshop in Montpelier, in Virginia, where, there were experts, called. I was lucky to be included. Canadian people, there are people from Ghana and all that. And all the top party lawyers in terms of MDC, ZAPU, PF, all of them came. And we were confined to this area, a farm, where there was nowhere to go. So we had breakfast together, lunch together, dinner together, and just discussing the text and all that. That was very beneficial because at some level, constitutional development is a matter of expertise. You need the technical understanding of how these things fit in. And the examples of the problems when you don't have good technical advice. If you look at the current Zambian constitution, I mean, we discuss a lot about amendments. Me, I actually think that the amendment provision in the Zambian constitution, which requires a referendum, is something that I've never seen anywhere in the constitution. It's good to say 2/3, fine, that's common. But it's often 2/3 of voters, people who voted, or registered voters. But the Zambian constitution, you go and read 79, it says 2/3 of eligible voters. I don't know who keeps a register of eligible voters anywhere. That's very poor drafting, creeping into a constitution, which is going to cause problems. And that even requires consensus more, so that if you're to get, over that thing, you really would have to get very good consensus in the way of the process, how you are going to change the constitution. Yeah, but just, everybody claiming to be expert, everybody claiming to be people, the church, NGOs. I've never had in my negotiations. I mean, I've never had to deal with those kind of crowds. I mean, it's really clear. I'm not saying they're not important. They're extremely important, but they should understand that they're on view. But we have to define what is people. And also remember that once the constitution is developed, yes, the sovereign power of any country and the power is in the people. But that dissolved after the constitution is actually, dissolved. By that I mean it's not in place. It's like the thing that developed the South African constitution, the Constitutional Assembly, is not in place. It's not there. It's not as if you can go to it, and it's not there. Whether you look at the Namibia, the people create an institution which is going to be the organizing group that makes sure that they're in charge. And we have to do that. Yeah. So, yeah, I'm sorry I've taken too long to speak about these things. Maybe you have some questions. Yeah.
No, Prof. It's always very enjoyable to listen to you speak about the Constitution, and I think you've covered quite a bit on the topic in relation to the need to define what even is the people in that specific context, and the need for expertise as we are developing a constitution. In closing, is there anything that you would want to say or add to what we have discussed so far?
Yeah, no, just to thank you, but also just to emphasize really that in Zambia, we need to take this constitutional development in a proper perspective and debate it and create forums that will produce something for us. Now, again, I want to refer to another example. In Kenya, when the 2010 constitution was developed, agreed upon, even there, as I pointed out, we had the experts. There was presidentialism, the people look at the legislature and experts, not in the end, the agreed constitution in terms of taking it all around the country to see whether people accept it. It was not the government, it was not the political party, it was the committee of experts. Because they say, here is the document, this is why we think it's good. And they went throughout the districts. And you see, the result is that the referendum, very high percentage voted for the constitution. And you go to Kenya today, people have these booklets, isn't it? They always talk about these are my rights here. This. So everything it becomes, because the process of adoption should also be educational to the people to understand. You see, just collecting views, believe you me, in the Kenyan context, I remember, I don't know whether it was a million or what, half the people that that's why I emphasize the importance of even like guidance in terms of expertise. Half the stuff you're going to get from people genuinely, they mean genuinely, but they use the forums just to complain about labor, there's no employment, there's no this. And of course, as a person looking at those, I wouldn't say to a person, oh, your submission is useless. No, they've done their best. They've tried to. But it's up to me to say, okay, they should feel good because it's part of them feeling, part of the process. But I shouldn't abuse them to say, oh, but your things are useless and all, because that's expertise. They're not experts. So I need to do that. Yeah. But the critical thing about public participation, but it should be properly organized and not be dependent on people who have set up all kinds of outfits and then they come and tell you change, NGO, this and then they tell you just public participation. That's not true. It's not, And the importance of public participation to me, again, I would rely on a quotation to end our discussion. And this is Chief Justice, Mohammed. He was the first non-white Chief Justice of South Africa. And he was very instrumental in the Namibian constitution. And he said so the question was posed to him that, what do you think is when you say you've had a success in the constitutional development? He says, the document must speak to the people. So when the people, if I look into the document, I say, yeah, it's talking to me. This is really, it's relevant. It's talking to me. That's what you should aim at. You are talking to people, and it is talking to me. I can see myself, rather than something that I don't connect at all. Yeah, and that's the test. And it's not mathematics, that you can say 2 plus 3 is equal to public participation. No, you have to structure these things. And even the decision making, when you've structured the organization, how are you going to make decisions in the process? And that's why I drew your attention to the South African process in terms of it was agreed, no voting in any discussions. We just have to agree. If we don't agree, we talk the whole week about the provision until we come to a consensus that this is what would work. Yeah, and I think those, you can see deliberate planning, focusing on this inclusiveness. Everybody is important, and that's what is the key to success, I think. Yeah. So thank you so much for the opportunity to discuss these issues.
Thank you for sharing your insights on this, and hopefully we can have another conversation of this nature in the near future.
Thank you. Thank you so much, Maria. And, delightful talking to you. Just also enabled me to think through some things, that you don't, when you ask questions, it forces one to reflect, So I always benefit from that. All the time you learn something. So I learned to refine some of my thoughts even as we discussed the issues. Yeah, thank you very much.
All right, thank you very much, Prof. And thank you to our listeners for joining us on our first episode of the podcast. Thank you for all of the followers as well on our socials. We hope to continue this conversation and see you in the next one.